Aloha and good morning, everybody, to this May's monthly meeting of our Hawaii Correctional Systems Oversight Commission. I see we have Commissioner Town here, Commissioner Torney. I believe Ted's going to be a little late, and Ron will not be making it today. So there's three of us who are here at this time. And I expect Mr. Sakai in a few minutes. But with no further ado, thank you everybody for showing up today. You know, it's kind of what we call the doldrums in regards to everything that's happening in the legislative session. So there's kind of a quiet as we anticipate the potentials of the signing of a lot of the new bills that have just passed. So as we have that thought, we go into the meeting. The agenda will be followed as printed. We will make some exceptions depending on where we are in terms of item 6, was the discussions of findings of fact, conclusions of law and order in the O'Malley et al. Case. There are individuals here will be giving an informational briefing to the commissioners on the status of the case and the concerns with public safety and the management of their mental health program. And so with that being said, let's move to item 1. And anyone having any public testimony at this time on the agenda items? I'm trying to
would like to say something, Chair.
Go ahead,
This is
Kat.
Kat. I'm sure you're all aware of the big hoopla about the bail bill. And we sure hope that the commission will talk to the governor about signing that bill, because it's really been weakened. So it's not as scary as people are making it out to be. They're giving half the information, but Hawaii has actually enjoyed one of the relatively lowest crime rates in the nation. And they're totally ignoring that fact. So we just want to urge the commission to talk to the governor, because the community is working on this. Thank you.
Thank you, Kat.
Mark, I do have a question. The governor's office sends out to people who are agencies that are related to a bill that he's considering a form to make comments on it. Have you received one of those? Because we should have received one of those on that bill, the bail bill.
I don't recall. Lisa, can you help me on that?
I'm not quite sure what Martha is referring to.
Okay, it has been 7 years since I left state government, or 8 when it comes to legislative sessions. But bills that were going to the governor's desk, there is a form that would be sent to affected state agencies, departments, like the public defenders, you know, all criminal justice will go to the public defenders, to prosecutors, to the police, asking for comments on that bill. And then it would be the policy people at the governor's office, and I realize EGA has very few policy people, but they would review those, and that would be one of the ways you get input. And it appears we haven't even received that form to fill out.
He said it's the CNR form.
So we're gonna have to,
What
hey,
was that, Max?
Max, I see you sitting there. Do you know what I'm talking about, getting those forms to fill out on bills?
It's called the CNR form. I'm not sure what CNR stands for, but it's called the CNR form that's issued out from the governor's office.
Okay, so we have not received one of those, it appears, and therefore we should be writing a letter to the governor.
Comments and recommendations.
Comments and recommendations, yeah. Okay, thank you. It lets us know once again that we really don't matter that we haven't received one of those, because we should have.
So,
Yeah.
Martha, we're already on record, aren't we, in support of the bill, are we not?
Yes.
Yeah, but
mean-
this is the last opportunity to get your voice heard by the governor as he's considering whether to sign or not to sign, or let it become law without signature.
Okay, we'll follow up, Martha.
Thank you.
Thank you. Thank you, Kat. Anyone else have any comments? You just raise your hand, your digital hand or your real hand. Okay, it's a quiet day today.
I see there's a question in the chat. What is PSD? And it's really DPS now. PSD used to be the initial for Public Safety Department, but because when we were created, there was a Personnel Services Department, so you would have had 2 DPSs.
Yeah, so this is Carrie Ann Chirota from ACLU. I do know what I meant to write something and I just accidentally hit the button without finishing the question. But I guess I was going to go on record as to saying, because the commission has submitted testimony in support of HB 1567, I think it is important and not to wait for the governor to send you this CNR form, because we know just in his decision-making not to appoint the oversight commissioner for several years that it's not a priority. And I'm curious because the commission is tasked and the public safety director officials are here, what is also the Department of Public Safety's position regarding this measure in light of a lot of pushback and misinformation that's circulating by law enforcement, by other governmental agencies about what the bill does and what it does not do. And just keeping in mind that there are 20 exemptions to the bill. And the last exemption specifically states that if the judge believes that the person poses a serious risk of harm to any specific individual or the public, and or that they believe that there's a risk of recidivism, which we know it can be anywhere to 50–60% based upon our current numbers, that is essentially a catch-all category that courts entirely have discretion to exercise and detain a person if they choose so. So despite the fact that the ACLU believes that the bill is significantly watered down and we would have preferred a different measure, I think hearing from the Oversight Commission and from the Department of Public Safety in terms of also reducing the incarcerated population, I think it would have impact on the governor. Thank you.
Thank you, Carrie Ann.
We can discuss that more when we get to item number 5.
Yes. Okay. All right. Let's move on to item number 2. This is the update on the hiring of the oversight coordinator. So as you folks know, and I believe Civil Beat might have printed an article out, we as the commission have decided to wait one more. The oversight coordinator has been hired, has been identified, and currently going through the personnel process. Yeah, once the personnel process has been confirmed and dates set, we will announce from the commission's perspective the new coordinator at this time. But she is in the process of going through the personnel with the Attorney General, and we hope to have her on board in the next 2 months. So that's my announcement of that. Go ahead, Martha.
She's relocating from the mainland.
Yes, she will be joining us from her oversight role in another state. So she comes very experienced. We're very excited to have her at this time. And we will save the next meeting for the announcement of our new oversight coordinator once the personnel process is completed. So thank you, everybody. We're very excited about this. Moving on to item 3. Max, you want to give us an update on the COVID-19 situation within the Department of Public Safety? Thank you.
As of the 17th of May, we had 8. We had 8 active inmates. We had 5 at HCCSOC and 3 at Halava Correctional Facility. As of the 17th of May, we had 18 staff that were identified positives, active cases. This is very concerning because of the community spread. And as you all know, that the higher the community spread, the likelihood that it eventually get into our facilities. We're doing our best to mitigate that spread. As far as boosters, these are cumulative numbers for Saguaro. They've administered the second dose, fully vaccinated, 992. Again, this is cumulative numbers, not the current population numbers. And they boosted 539 inmates there. on in Hawaii, final doses. And this is as of May 9th, 2022. We administered 3,642 final doses. The initial booster, the first booster, we gave 1,291. And the second booster, we administered 23 so far. That's all I have at this time.
Max, we do have a comment, and that is someone is asking, aren't women at WCCC in quarantine because of an ACO case?
Yes. Staff at Women's, we had 2 active cases there with staff.
And so the women are in isolation. I mean, how do you handle the inmates?
Yeah, part of the facility is in lockdown quarantine. Yeah, they're not isolated.
What does lockdown mean?
We only isolate if they're positive.
Okay.
They put in medical isolation if they're positive, but it's basically stopping the movement so that we don't cross-contaminate housing units in the event somebody is positive.
And so this for everyone here, when they're in lockdown, basically what activities do they have?
It's limited. It's limited, and it basically pertains to what's available in that housing. Yeah.
So programs are not coming into them or anything.
Programs are still running if as safely as we can allow it to happen.
Yeah.
We've been running programs at
Okay, thank you.
It's just to mention that when we talk about quarantine and lockdown, I think it's a safe statement to say half of the housing at the Women's Community Correctional Center are dormitory.
Yeah.
Yeah. So depending on where the quarantine is, they either can be in a cell or majority of them would be in dormitories.
The reason I was asking for clarification is, like boredom can lead to the idleness is the devil's workshop. So I was wondering what kind of activities the women who were in lockdown still had so they wouldn't become so idle during that time.
We want to, at the same moment as we're discussing this, Max, I appreciate the COVID report. I'm sorry if I missed it. Did we mention anything in Arizona about Arizona?
He started off with Arizona.
Okay. My apologies.
We don't have any infections in Arizona reported at this time. So
Okay.
Just the numbers.
With the current report that you just gave, is there how much of normalcy has returned back into the facilities statewide in terms of returning back to quote unquote normal visitations, programming,
Yeah, so
furlough?
I think if we're moving into number 4, I think Tommy's going to give you an update on what the new normal is.
Okay. Yes. I didn't have commissioners. If you had any more questions on the COVID report, if not, we're gonna move on to the next agenda item. Thank you, Tommy.
All right, so all the programs in the facilities are up and running again. Arizona's up and running. The GTL tablets are running for visitations. We're still finishing the installation and kinks on some of the GTL tablets here in Hawaii. All the educational programs are up and running. The only time we had to cancel programs or visitations are due to staff shortages. Work furlough and extended furloughs up and running. We have a total of 193 inmates participating in the furlough and extended furlough. That's 151 in furlough and 93 and 42 on extended furlough, and 6 participating female offenders participating at the YMCA Fernhurst. So
the inmates that are on extended furlough, are they spread throughout the state?
Yes, they are. Yes, they are. There are 10 on extended furlough from OCCC, 3 from Women's, 10 from Maui, 5 from Kauai, and 14 with HCCC, for a total of 42.
Thank you.
Max, I know the state is across the board all having vacancy issues and hiring. And of course, without staff, it's hard to get back to normal. Has there been any changes in your vacancy numbers?
We've been running our basic recruit training pretty rigorously. We just had a graduation 2 weeks ago, and 26, I think, new ACOs hitting the facility. Unfortunately, the numbers that are retiring are just as high as what we're putting in the facility. So, you know, we're making strides in filling vacancies, but then we also have new vacancies that are occurring because of retirement and other issues. We will continue. We're starting a new, I think we started a new class, yeah, on Monday. You know, so we're doubling up on the amount of training that we're providing, you know, for recruits. But you know, it's going to be a while before we can actually fill all of our positions comfortably.
I believe in the previous meeting with just the correctional staff, you may have reported, and this is not unsure, but close to 200 to 300 vacant correctional officers.
Yeah, we had a high level of vacancies, and you know, Mark, you got to understand, it's not just the vacancies, but it's the, you know, workman's comp.
Yes. Okay.
FMLA, in addition to the regular sick leave and vacations that we got to deal with as far as staff shortages.
Understanding, Max. I wanted to just raise those questions, and when Tommy mentioned that the postponement of programs and visits have only been due to lack of staff. Yeah. And any kind of in a correctional center, that's almost normal as well. Yeah.
We, you know, I think on Mother's Day, there were some concerns at WCCC about visitations on that day, but I need to give credit to the warden there. You know, he pulled all resources, including himself, to come in that weekend to ensure that visitations took place. Staff is going beyond, you know, what they're required to do to try to get things moving. I appreciate that. Okay.
And Martha, this may not be my wheelhouse, but earlier in my career, emergency hires were the norm. And then all of a sudden the state stopped that practice with correctional officers. Has that been looked at, Max, in terms of upping an emergency hire process to expedite filling those vacancies?
Yeah, we've taken on emergency hires, you know, and we've had quite a few that did come in, you know, to assist in certain posts within different facilities. So yes, we are taking advantage of the 80-90 hire.
Okay. Thank you, Max, for answering that. Commissioners, any more questions regarding the programming aspects of the department as we move forward to normal?
I just want to prepare the department as we get staff on board, Max and Tommy. You know that one of our main focuses is on the reentry of inmates. So that is like something I'm going to be concentrating on, getting information about what programs are available, how many people are actually participating, fulfilling programs and stuff. So maybe sometime in the next few months, we can start meeting on how we'll be collecting that data.
Sure. Just let us know what are the variables that you're looking at, Martha.
And I would like us to work on that together, what you folks think are important too.
Sure.
Okay, no further discussion on this item. Thank you, Max, for all you're doing in bringing that department back to normal on that case. No, item 5 is the, excuse me, Martha.
Oh, sorry. There's a question in the chat by Carolyn. I don't know if Max can
He
answer.
asked how many weeks or how long is training?
Right now, our corrections recruits go through 10 weeks of training.
And emergency hires, what do they get in the way of training?
2 weeks of training.
So it's not the best thing to be using emergency hires, but I understand the need for
Oh,
them.
and then the posts that they're assigned to is very limited too. You know, they can't do, you know, full correctional officer duty. A lot of the 89-day hires, you know, do apply and they do fall into the next recruit class, you know.
What? I'm sorry, I didn't hear that.
A lot of the 89-day hires that we pick up, they apply and they become, you know, part of the academy training in the next session.
Thank you.
Thank you, Max. Tommy, moving on to item 5. Martha, since the public testimony till now, that information about the CNR, it may be something that we might want to do for a lot of the bills that come through, yeah?
Yeah, so Ted, before you came on, we were talking about the fact that we have not received from the governor's office any of those requests for comments and recommendations on bills. So we're going to have to be writing letters instead.
Okay, got it.
Okay.
So,
So, yeah, we should be, anything we testified that we think is really important, such as the bail bill, we should be writing a letter.
I'll get in touch with some of the people in the community that have been supporting me on tracking some of the bills that have been crucial to moving our public safety department into a more therapeutic model. And let's see what kind of testimony we can provide to the governor on those that would be sitting on his desk.
Yeah, and we need to do it very quickly.
Yeah, I know that Ron can provide us, has always provided the testimony and support for the bail reform, but there is a lot of the programmatic bills that went through as well regarding the women and the ID, I believe, went through,
Oh, yeah.
et cetera, et cetera. And so I'm not prepared to talk about all of that right now, but we will move forward in trying to get a CNR or our own comments to those legislative actions so that we can move.
And some bills we didn't testify on, like I don't believe we testified on the bill relating to additional funds for pre-release or for release programs for like furlough programs. I believe $1 million passed on that. So we also should be commenting on
Yes.
things that support our goals.
Yeah. We'll have to review that and make our recommendations on further support of these bills that will be sitting on these desks. So thank you, Kat, for bringing that to our attention. I don't see us.
I'm gonna listen. This is fascinating.
Any other comments on agenda 5, commissioners?
No reform.
I know, like I said, mentioned earlier, Ted, we're kind of like in the doldrums right now as we wait from the end of the session to the governor signing and seeing all the rhetoric that's going through in the media on the bills that are making their way toward the governor's office. So as we continue to move on and probably have a deeper discussion the next month on that particular agenda item, let's look at item 6. Discussion of findings of fact, conclusion of law and order in O'Malley. And mind everyone, this is an informational that we are allowed, commission is allowing to find out more information in regards to the mental health system within the Department of Public Safety in a recent case that we've heard. And we mentioned it briefly last meeting. And we just want to bring some of the players here to have a discussion on what they find to be some of the concerns that the Oversight Commission should be reviewing and perhaps following up on now that the closure of the case has been decided. So with that, for the next 15 or 20 minutes, we'll just open the floor. And Bob, can you begin? He's on the phone. Let me see. Mr. Livingston, would you want to start the introductions?
Sure. Thank
Bob's
you,
off
Chair
the
Patrick.
phone. Bob's off the phone. Bob, you there?
Yeah, Mike, I'm here. I just left, I got Dr. Stewart's voicemail, unfortunately. So I'm going to keep trying him. But I got referred to his voicemail, but go ahead.
Mr. Livingston, go ahead. Well, Bob, I said, did you want to do an introduction or you just move ahead?
No, just move ahead. Others will take care of it.
Thank you, Bob.
Yeah, the report kind of speaks for itself anyway.
Yeah.
Yes, if I may, Chair Patterson, Commission members, I appreciate the opportunity to answer questions and make some comments here. Also, we have Mike O'Malley, who, of course, brought the lawsuit on behalf of his son. And also, I think on standby is Dr. Stewart, Dr. Pablo Stewart, who was our expert in the case and who has a very deep knowledge of correctional psychiatry generally, and also a deep knowledge of psychiatry as it's practiced in the Hawaii correctional system. The case involving Joey O'Malley, truly tragic, and as Commissioner Sakai observed, the findings of fact and conclusions of law that were issued by Judge Tanaki are pretty clear and do speak for themselves. I also understand that the Commission may have been provided with a copy of Dr. Stewart's expert report, which was prepared in connection with the case. And we would, commend the state for having made Dr. Stewart's report part of the public record, because it really does go much deeper into the issues that we discovered during our litigation. Many of those issues were not addressed at trial because the state stipulated to liability in the case, based, I think, substantially on the findings that are reflected in Dr. Stewart's report. Essentially, and Dr. Stewart, assuming he is able to join us here this morning, will be able to speak more directly to some of the issues involving the treatment of mentally ill prisoners, and in particular those who are seriously mentally ill. But I could just take a moment and highlight some of the major findings. I think that might be helpful, and then turn it over to Mike O'Malley and hopefully Dr. Stewart. One of the interesting things that we found was that the policies are really pretty good. They do, in general, reflect best practices. They arose out of a consent decree in 2008 related to OCCC, and then those were revised in 2013. And these are standards related to mental health care in the prisons, and in particular to suicide prevention. And then those standards, which were agreed out of litigation brought by the Department of Justice, were adopted by the Department of Public Safety and implemented in a suicide prevention policy. And what we found was that that policy was, in general, pretty consistent with best practices and with standard of care. The troubling thing that we found is that those policies were largely ignored. And I can just go through some of the major points, and these are addressed in much greater detail in Dr. Stewart's report. But first, and perhaps an overarching concern, was the lack of training. And that's reflected not only in the way that the issues that pertain to our case arose, but also generally, we found that there was a really fairly appalling lack of knowledge among staff, including even psychiatric staff, mental health care workers, about the policies that are reflected in the suicide prevention policy. The monitoring of inmates who are on either suicide watch or safety watch was very deficient in our case. And the systemic problem that we identified, which was quite surprising, was that the guard scan system that was mandated by the 2013 consent revision and then adopted by the Department of Corrections across its facilities. And the guard scan system was where the guards walk the halls and have to use a wand to trigger various points. That system was implemented as a device to enhance the monitoring and observation of the inmates. But what we found was that it probably had the opposite effect, because when we looked at the videos of the ward, this is the ward that has the suicide watch and safety watch cells. When you look at the hallway, you see the guards, the ACOs, walking straight down the middle of the hallway just to touch their wand to the various ports without looking into the cells. So they were walking the hallways every 15 minutes, and the electronic record of the guard scan system showed that they were appropriately using their wands at the various stations. They weren't looking in the cells, and that, of course, is a systemic problem that is fairly easily corrected.
Sorry, just to interrupt real quick, Chair Patterson, could you let Tommy Otake in from the waiting room? So sorry to interrupt.
Sorry, I was so into the thing. Okay, there you go. Thank you.
Yeah, Tommy was a lead member of our trial team as well.
Mark, can I ask Mr. Livingston a real quick question at this point?
Yes.
Mr. Livingston, when you described the guard stand system at the end of the hall, one at the end of the hall, was it for safety watch or also the same for the corridor in which suicide watch was held?
Well, it was for the same hallway.
Oh, it's the same. Okay.
It's the same hallway, but the suicide watch cells in general had video, and there was a guard station which had access to video monitors in each of those cells. So there was that potential for monitoring in addition to walking the halls and physically looking in the windows of the cells. But for some of the safety watch cells, in particular the observation cell in which Joey was held, there was no video coverage. So the only way to actually monitor the prisoner was to look through the openings into the cell.
Thank you.
I see that Dr. Stewart has joined us, and he is certainly much more knowledgeable about the mental health issues. And so if the commission has questions for him, I can come back. I know his time is precious, so perhaps I'll let the commission talk with Dr. Stewart, and then I can come back and answer further questions.
Hi, good morning. My name is Pablo Stewart, and right now I'm working over at Queens, so I was able to block off some time right now. So I'm more than happy to answer questions or present my opinions about this particular case and its implications for the entire Department of Safety.
when we were reading when I read the report, Dr. Stewart, I can see there's two issues that came to my mind. And Mr. Livingston was talking about what I refer to as the custodial issue,
Right.
which involves security. I'm wondering if you could kind of share to us what you felt was the mental health issues.
No, absolutely. And if I'm telling you stuff you guys are already familiar with, just tell me to stop. But as far as the provision of mental health care in a correctional setting like Halava or OCCC or any of the prisons and jails we have here in Hawaii, there's a constitutional requirement to provide community level care. And so what that means is that people have timely access to psychiatric care with up-to-date medications, and that was not occurring. There was, as I mentioned in my report and stated on the record, is that the psychiatric care being provided was significantly less than what we call standard of care. They were using first generation medications where now we don't even use those because they're so old and outdated. That was one thing that first caught me about this. Another thing is that when a person is identified as needing to be on a suicide watch or a safety watch, the term that is used is that that person requires aggressive mental health treatment to address the issue for which they are on suicide watch or safety watch. You just don't lock them in a cell. Basically, they're in there like they're in solitary confinement, because solitary confinement has been absolutely shown to worsen people's mental health issues. So I didn't see where he was getting any kind of adequate treatment while he was on the suicide watch or safety watch. The psychiatrist would see him, but she'd come up to the cell front and talk to him through the door. And the same for anybody else that was seeing him. So he wasn't getting anywhere close to adequate mental health care during his time there on suicide watch and safety watch. And the fact that he was in this solitary confinement-like situation was only serving to make his mental illness worse. So all of those things were at play. And
Question, Mike Town. Do you know what the word iatrogenic means? I know you don't. I'm asking you an easy question. What does that mean to you?
Iatrogenic is when something is caused by, we call it physician iatrogenic. That means the doctor is causing it, or the situation is causing the problem.
Yeah, it's like, I use the word geogenic, but people are in there to be helped and cured and certainly not injured and hurt. And what I hear you saying, maybe I don't want to put words in your mouth. This was a iatrogenic or geogenic situation. Am I off on that?
There was a lot of aspects to it that were iatrogenic. Absolutely.
Are there any studies on that? I mean, I read your report twice. It's hard to read it and then sleep. and that's a positive, because so any studies or best practices nationally that have actually solved this problem?
Well, there are best practices. And the best practices that, because see, in this particular case, Mr. O'Malley fell into a variety of situations. He was seriously mentally ill. He was episodically suicidal. He was then placed in segregated housing or solitary confinement. There are best practices that address each one of those particular items of his care. The best practice for mentally ill in solitary confinement is that you screen someone before you would even place them in a solitary confinement situation. And if based on the severity of the mental illness, they wouldn't be placed there in the first place. If you're going to put someone in a solitary confinement-like situation, like he was on safety watch and suicide watch, then the responsibility is to the treating staff is to see him daily, to have him come out of his cell, for individual therapies, to participate in yard activities, to be able to get out, walk around, to minimize the effect of solitary confinement on someone who has serious mental illness. So those are the best practices.
Dr. Felix Lee, 14798. Dr. Felix Lee, 14798.
And in addition, there are best practices for the use of psychotropic medications. And he was not getting those. I really couldn't understand, and I've been doing this work for about 40 years, of why he was being treated with these outdated medications.
Why wasn't he at Hawaii State Hospital?
Well, see, then that's the next part I wanted to get to, that the standard of care is for a correctional setting, that if a person's mental illness exceeds the facility's ability to treat it safely, then that person needs to be transferred to an inpatient facility, or as we say, a higher level of care. Now, what I discovered throughout this whole case was that the Department of Safety has policies and procedures that say, yeah, when someone is so mentally ill that they're unsafe to be housed in the jail, then they should be moved to a higher level of care. But I'm not aware of that ever occurring for mental health reasons. There are people that are in, like I work at OCCC 1 day a week. There are people there that are mentally ill in OCCC, but then they're found not fit to proceed and they're moved to state hospital for return to fitness. But I've never seen one patient moved from OCCC to, say, Kakela or any other inpatient psychiatric facility, including the state hospital, because of the severity of their mental illness. And I guarantee you, in this particular case, in Mr. O'Malley's case, his mental illness absolutely exceeded the ability of the facility to treat adequately. And he should have been moved to an inpatient setting early on in his stay at Halava.
Thank you.
Dr. Martinez, this is Martha. I'm one of the
Dr.
commissioners.
Stewart, actually.
Oh, I'm sorry, Dr. Stewart. I worked with another Pablo Martinez, sorry. You have obviously testified in many, many cases and worked for correctional departments in different areas. I'm sure you've seen lots of barriers to creating or to providing adequate medical care or mental health care. What do you see as the biggest barriers generally in doing this?
Boy, there's not just one barrier.
Yeah.
Since mental health care is being provided in the correctional setting, it is absolute, in order to have adequate mental health care, the first thing that you need to have is adequate custodial care. And the understaffing, the fact that guards at OCCC have to stay on for 24 hours in a row, that there's not enough people to adequately watch and monitor the suicidal patients. That's one thing. So the first thing is lack of a robust custodial system. And then next of all, I would think it's an attitudinal issue where Mr. O'Malley was severely mentally ill, but yet, and this is my speculation because I never saw anything documented about this. In my experience, I see that the custodial staff would say, "Oh, he's just a jerk. He's just a bad guy. And this is not real mental illness. And what is his voices? No one hears voices. He's just making that up." So there's that part of it too. That's attitudinal about the whole system. And as it turns out, we have to be real honest that the Department of Safety is one of the biggest providers, if not the biggest provider of mental health care in the state of Hawaii. And so in that sense, it should be a robust system, and it frankly is not. So those are the sort of major issues. lack of adequate custodial care, this attitudinal problem, and then the next thing down the line on this, and they all interplay, is having competent mental health staff. You know, you just because someone can call themselves a doctor doesn't mean they're adequate, they're competent mental health staff. And based on my experiences, not just in the mainland, but here in Hawaii, where I've been working in the correctional system for 3 years, some of the most complicated, serious mental health cases I've ever encountered occur in the custodial system. So if anything, you need the best clinicians in a clinic, in the custodial system, because of the complexity of the mental health issues.
I think one more aspect of that is adequate supervision. That you have these people on the line that their sergeants or lieutenants may not be checking on them often enough to make sure they're doing the jobs properly.
Yeah, you know, and speaking of supervision, I'm very proud, frankly, of the quality of the psychiatric care that we're able to provide the prisoners in at OCCC, because we have 2 psychiatric residents from Jabson who are there, and there's an attending physician there every day with attending psychiatrist that's there every day with them, supervising each case. And so as far as the psychiatric care at OCCC, I think it's for the cases that the residents take care of is really top notch. But other than that, I can't speak to the quality of the care. You know, if the O'Malley case is exemplary of the level of psychiatric care, then I think we're in trouble.
Dr. Stewart.
Yes.
I know this goes back to 2017, but before you came on, Mr. Livingston mentioned an agreement with the Department of Justice. It was a settlement agreement, not a consent decree, by the way. But anyway, under that, we established the treatment modules at OCCC, a treatment module and a step down module. Did you see was there anything equivalent to that at Halava?
You know, I'm not aware of that at Halava. I know that at OCCC, there's a what they call it, an acute unit and a step down unit, but I'm not aware of any facility like that at Halava.
Yeah, my issue with the department goes back quite a ways, but you know, I left the department more than a few years ago. But back then, we used OCCC to work with the mentally ill inmates from the jail system, and any mentally ill inmates from the prison system would go to Halava. So I was just wondering if Halava had been able to establish a similar type of system.
You know, I just don't know, sir. I'm sorry.
Okay, so for Mr. O'Malley then, other than suicide and safety watch, do you know what kind of treatment he was being provided other than the medications you previously mentioned?
That was basically his treatment. He had some people come and speak to him once in a while, but based on reviewing his records, it didn't appear that there was any sort of coordinated multidisciplinary treatment approach that would address him from both a psychopharmacologic standpoint or a psychotherapeutic standpoint, or just an activity standpoint. You know, you keep mentally ill people locked in themselves all day and they will get worse and they will self-harm. And I think this is a perfect example of that.
I have another question about visitation. Were you aware whether Mike's family was able to visit him during the time he was in the suicide watch and the step down?
You know, that I don't know. Maybe Mr. Livingston or Mr. O'Malley.
On the line, so he might be able to answer that.
Yeah.
They were not able to visit. That's another area where the policies actually allow visitation. They allow in safety watch all of the normal privileges of the general population, unless a mental health professional provides a written order otherwise. But the way it worked in practice was kind of the opposite. You only had privileges to the extent that they were explicitly provided by the overseeing psychiatrist. And in practice, I'm not aware of any instance in which there was visitation allowed to a prisoner being held in either safety watch or suicide watch. And similarly, other kinds of privileges. At least based on the information we were able to obtain in our case, it appeared that the prisoners being held in either safety watch or suicide watch were basically held in the equivalent of solitary confinement for 23 hours a day, allowed out to shower, and that was it. And even within their cells, they were very limited in what they could have. On suicide watch, it was basically nothing. And you'd also be in a suicide gown, so not even clothing. And then on safety watch, you might have a mattress during the day, but other than that, unless the attending psychiatrist ordered, you wouldn't be allowed any other thing in the cell. And the cells, as you're probably aware, were inappropriate. Not only were they just bare cement cells, but they had protuberances which allowed an inmate to affix a ligature. And that's an explicit violation of a policy. Again, a policy that exists but was ignored. I think that may have been corrected as a response to our lawsuit, but all of the cells in the suicide watch and safety watch had exposed bars to which a prisoner could affix a ligature. As Dr. Stewart pointed out, there are many aspects to this that make prison setting inappropriate for the treatment of seriously mentally ill people.
Mr. Livingston, Mike Town here. Did I read Dr. Stewart's report correctly that Joey in fact tore up part of his suicide gown to hang himself? Did I miss that?
No, that's correct. The ligature.
How can that be? That's crazy.
It is crazy, and we asked the ACOs and others in deposition whether they had seen that before. Some said, "Oh yeah, we've seen that before." Others said, "We've never seen that before." But clearly, a suicide gown shouldn't be susceptible to being fashioned into a ligature used to suicide. But that was in fact what happened. And to our investigation did not find any implement or even any investigation actually by the department into how he could have created that ligature out of the suicide smock.
And if I may add to that, the ligature itself, or the section that was cut out of the suicide smock, was done in almost surgical precision, like Mr. O'Malley had access to a sharp object, that he was able to cut this particular piece of fabric that he did use for a ligature. And I'm not trying to, I'm not trying to say or accuse anybody of this, but in my experience of working with prison systems in the mainland, it is not unheard of that custody staff somehow allow a person to have a sharp object to do things for self-harm. And so I'm not saying that it happened here, but that's something that we need to keep in the back of our minds.
There is a section of Dr. Stewart's report. It's the last section, I think it's section F, in which he lists a whole series of systemic problems that in his opinion, made it virtually impossible for appropriate psychiatric care to be provided to seriously mentally ill inmates at Halava. And that's a pretty good summary of much of the earlier portions of his report. And I think he puts into context there the way that that Joey's case may reflect the more systemic problems that we found at the institution.
Mr. Livingston, I have a question for you or Mr. Otake or even Dr. Stewart. Was there a criminal investigation here? Because I'm without getting into it too much, I know we're going to dance around on this, but is there a conscious disregard here of death or serious bodily injury by the staff? How did that go?
Well, we brought the case under the State Tort Claims Act rather than as a constitutional case. At the outset of this case, we knew very little about what happened. We knew that Joey had died by suicide while in safety watch, and that, of course, raised some very serious red flags. And then I think it would be interesting for the commission to hear from Mike O'Malley about why he decided to move ahead with this case. But what we found essentially was that once we got into the case, was that the standard of deliberate indifference, which applies to constitutional violations and is probably a more rigorous standard than the standard of negligence that applies under the State Tort Claims Act.
Queen Emma Tower, 8th floor, near stairwell number 1, code red, Queen Emma Tower, 8th floor.
I think we easily could have met that standard, but the information that we developed through the litigation was not available to us at the outset. But I think Mike O'Malley can maybe briefly describe why he decided to move ahead with this.
Thank you, Mike. Chair Patterson, Judge Town, Mr. Sakai, and the rest of the commissioners, thank you for doing what you're doing, and thank you for allowing me and my attorneys this opportunity to talk to you. When I approached, well, let me back up. When I went to the hospital room after getting an ACO's call that my son stayed brain dead, and that was all he said. And I went in there, there was a internal affairs investigator from Halava there who greeted me outside the room and said that there would be a thorough and transparent investigation and that I'd be hearing from them and we'd learn what happened. That's the last communication I had with anyone at Halava, other than a form letter that came out 30 days later saying, pick up your son's stuff or we're going to throw it out in 30 days. So there's no follow-up. We didn't know what was going on. When I called the medical examiner's office 3 weeks after Joey's death to get a copy of the death certificate, she told me, Mr. O'Malley, can I tell you something? I said, sure. You sound like someone who's in a position to make a difference. Go get those bastards at Halava. I'm tired of them sending me bodies. And that statement just rang in my head. I went back and I talked to Mike Livingston and I didn't know each other, but it was highly recommended. And I asked if he could help me. And at that point, all I was really looking for was, what the hell happened? Can you help me do that? And Mike's, to his credit, was willing to help me. And then he spent an hour trying to talk me out of bringing the case not because he was afraid of it or didn't want to do it, but he knew how hard it would be on me. He said, it's like delaying the healing, picking at the scab. And after an hour, I said, I hear you loud and clear, but let's go forward. I had talked with my family, my wife and his 4 sisters, and they all said the same thing. Dad, if you don't do this, who's going to do it? And that their comments and the medical examiner's comments are what kept me going. I wanted to quit a lot of times over the last 4 years. We never expected the result that happened, just wanted to find out. But as I told the press when we had a press conference about the award is that this isn't the end for me. It was never about the money. Mike, I think it's fair to say you and I never thought we'd see a nickel. That wasn't why we did this. And so for me, it's just the beginning of a journey with all you folks to see if we can change things, because my folks always told me that the way you measure a community is how they treat the least among us. And if this is any fair measurement, then we're sorely lacking and we need to fix things. And that's really what we're trying to do here. I really appreciate what this commission does in particular. And I hope I can play whatever small part I can going forward to be part of that change that we really need. I mean, we were shocked when we found out what was going on there.
Mr. O'Malley, I want to say that the commission is only going to be successful if we continue to have participation from people like you. The public that participates with us is really what moves us forward. So I appreciate that.
Thank you.
It might be interesting for the commission to hear briefly from Tommy Otake. He's probably spent more time, well, I know he spent more time in these institutions than the other attorneys on the trial team. And so he has I think a unique perspective, not only from his many, many years as a criminal defense attorney, including with the Public Defender's Office, but also having participated on the front lines in this case.
Thank you, Mike. And I want to echo what Mike O'Malley said. I just want to thank all of you on the commission for the important work you're doing. Really, really appreciate it, and also appreciate allowing us to share with you some of the things we learned. It's not an understatement when I say in my 20 years of practicing law, I viewed this as one of the most important cases I've ever worked on. And I spent years and years in criminal defense, going into HCSOC, Halava, representing a lot of mentally ill clients and feeling a bit helpless at times. When Mike O'Malley, had the courage to do this, we were behind him all the way and really learned a lot. And of course, learned tremendous amount from Dr. Stewart. And it was really interesting because as we were working on this case, I had a longtime client for probably been representing him for maybe over 10, 11 years who, was fortunate enough to have been found, not penally responsible because he was mentally ill enough to be acquitted and committed. And I'll never, I had a hearing for his case because he's still in the conditional release state hospital system. And he's doing great. And he was probably on the same level of mental illness as Joey, except, there's this group of, individuals who find themselves in the system and are not mentally ill enough to be acquitted and committed and end up in the Department of Health, but severely mentally ill enough where they'll never be able to comply with probation and end up in Halava. And it's interesting because in court, at the end of that proceeding, when you're found unfit and acquitted and committed, it says you're committed to the care and custody of the Department of Health. And that's what happened to my other client. And he's done fairly well because he's in the Department of Health system. Joey, when he finally couldn't comply with probation and was, resentenced, that's what was said was you're committed to the care and custody of the Department of Public Safety. And he went that route. And, it just, my other client, Anthony, is doing well and Joey's dead. And it's just heartbreaking, but I think we can learn from this. And I think one of the things that we all learned is it's going to keep happening unless there's changes. It's absolutely going to keep happening. And that's why we really appreciate your work. And we want to, one of the things our group, the attorneys, Chase Livingston, Hannah Masunaga, Mike Livingston, and myself, we all said, and with Mike O'Malley, we made a commitment, the case, it doesn't end with the case. We got to keep pushing for change because the case was always about more than just this individual case. It was about how do we learn from this? And we're not here to just criticize and point out problems. We want to help find solutions. And so whatever we can do to continue to work with you all, I can't say enough about Mike O'Malley. And his family, his daughters, and their testimony was, incredibly heartfelt, and I think moved the judge and the attorney general in the case. And I think I always appreciated him doing this because, like he said, this happens all the time, but unfortunately, it usually happens to families who maybe don't have the sophistication or the resources or the know-how to pursue change and relief. And I think Mike O'Malley realized that he was in a position to do this. And so anyway, I just appreciate your time, and I appreciate what you guys are doing. And if we can continue to help in any way, we'd love to do so.
Mr. Otake, can I ask you a little question?
Sure. Good to see you, Judge Town.
Here I am. I'm fine to be retired, but I flunked. I'm on the commission. The question is, the least, the lost, the left out, the lonely. That's who regularly I would see when I was a parole commissioner. And to me, we're fiduciaries for them. They're not just a defendant, a criminal, a parolee, or whatever. And what more can we do to help? This kind of a loaded question, to help folks that are in this situation. I've heard we can try to get them in the state hospital. I read Dr. Stewart's report twice, and I got to read it again now. We've got to get good therapists in there, third generation meds, and really an attitude of help. Our job on Act 179 is to be therapeutic. It seems to me, and I've said this before, and you've heard me say it before, that it's geogenic or iatrogenic. We're actually doing them harm. What more can we do?
That's a great question, Judge Town, and we've thought a lot about this. And one of the, like I mentioned earlier, it seems like there's, obviously the Department of Public Safety needs to do better, but at the same time, why is everybody operating in their own silos? Why is the Department of Health, not involved? Why isn't there collaboration between the two, where you have the expertise and professionals at the Department of Health, taking care of these things, and to be fair, the ACOs involved, they're there with the training that they got, and a lot of them, we think did care about Joey, but just they didn't have the training, and that's not their field, But to answer your question, I think, in our conversations, one incredible opportunity coming up is the design and build of the new jail. We see that as probably one of the biggest opportunities to make some meaningful change in this system. How do you design it? Bob Merce has spent an incredible amount of time looking into this, and how do you use that as an opportunity to reevaluate how we go about, this entire system? How do we build it in a way where it incorporates a lot of these things and the mandate, that your commission has? And so I think, to your question, it's going to take time, but the building of this jail could be a generational thing that changes the entire system in ways that are for the better. And if we don't take advantage of that, it's just going to go back to 30, 40 more years of the same approach. But I think everyone said about it, it's attitudinal, it's training, it's people like you guys on the commission and the community pushing for this. And I think we all kind of know what needs to happen. It's just, trying to keep at it. And but I think the building of the new jail is a great opportunity. And we want to try.
You did not argue to Judge Tanaki that there was deliberate indifference, as in the federal system or the criminal system. You walked away. That didn't get to your plate.
What happened procedurally is it was so egregious, the violations of policy. And by the time we were done with the depositions and discovery, it was truly indefensible. And to the Attorney General's credit, they ended up stipulating to liability on our negligence claims. So when we got to trial, it was primarily about damages, but of course the damages was related to the violations and the suffering and torture. So that came into the trial as well. But so to answer your questions, we didn't, and of course, we can't, under the state tort law, we can't get punitive damages against the state. So it was never a matter of trying to show recklessness or deliberate indifference, even though, as Mike Livingston stated, if we had to show that, I think we could have,
So right now, you're not aware there's any class action request in federal court? Or are you aware, but you don't want to comment on it?
I think, Mike, you want to speak to that?
Yeah, my understanding is that there is a class action pending in federal court. I think Eric Seitz is the lead attorney. And I don't know the status of that case, but it does directly address issues of mental health care in the prisons, not just Halava, but all the prisons, and in particular suicide.
Okay, because Carrie Ann Shirota just wrote in a question on that too, which she can get to. Same issue.
I have a question for any of the team. I understand, I read somewhere that Mr. O'Malley, Joey, was in Halava. He was committed to Halava on a probation violation. Is that correct?
Yeah.
That is correct.
Yeah, so the question that raises in my mind is, what kind of help was he getting while he was on probation? And it's very relevant to me because it's public knowledge that this commission has called for a pause in the planning of the new HCCC, and the main reason is so that issues like what services are available. By the way, it's much more than just because of bail reform. What services in the community are available to keep people away from jail. For example, mental health treatment. If there were better mental health treatment in the community for people like Joey O'Malley, would he be able to stay out of jail in the first place? And so this is a very relevant issue to me. Thank you.
Yeah, that's actually a great question. And, he made his way through the court system. I studied this. I went back and looked at his whole case. And, there was a time he was in drug court and getting support there. And then there was a time that, I think he might have been in whole probation for a bit. And I think they were trying to help him. But, in the end, like I mentioned, I think there was probably a failure to recognize that, some people, their mental illness is so severe that, complying with probation is probably, extremely difficult. And so I think it's a great question, and I think, ideally there would have been more that was done in a way that helped, that prevented him from getting the open term. But to be fair, they gave him his chances, he just, because of his mental illness, it's not as though the first time he, had a violation, they revoked him. But I think it's worth pointing out, out of fairness to Joey, this was his first arrest. He was, I think, 19 or 20. It was the only case he ever had that way, and, I think the probation system tried to work with him, and in the end, because of his mental illness. And I think Joey tried, I really do. It looks to me like he tried, to comply. And there were times he did well. And that's why, it was a really long, drawn out process. His criminal case, by the time he ended up in Halava, it was, probably eight years or so of, just making his way. He was unfit for a while pre-trial, and then he was in the state hospital. He did well. Then he was fit again, and then he was changed his plea, and then he was on probation, then he got violated. And so it was a long journey to Halava, but I think that's a great point, is what could have been done to have prevented him from ending up in Halava.
Yeah, I guess part of the point is that given the high level of people committed and detained in our correctional facilities with mental illness, what's the role of the Department of Health, not only within the facilities, but also in the community for the justice involved population?
I completely agree. And that's, again, when we talk about the opportunity for the development of the new jail, I mean, why wouldn't there be the Department of Health be there? Why wouldn't they have a role in that where they actually have, a section there or beds there that they manage, I mean,
it's a good idea.
I don't know, it just seems like it just really struck me when, we're dealing with Joey's case and I was still going to court for my other client, and it's just two different tracks, and it shouldn't be that way, and I think, it was discussed earlier, but there, and Dr. Stewart talked about it, there was a policy in place that said that, essentially if somebody was, mentally ill to a point where they couldn't be managed, they needed to be transferred to a higher level, like the state hospital. And what was shocking is, it was clear from the discovery that has never happened from Halava. There was never a case. I mean, we all know in the system, we see it all the time when someone is pre-trial at OCCC, unfit, they go to the state hospital. But once they're sentenced to the open term and they're at Halava, it appeared as though there's never been a situation where someone was transferred to the state hospital, at least not that staff and high level people were aware of, including the medical professionals that were working in Halava. They didn't know that was even a possibility. And so, yeah, I mean, I think that's one of the things we took from it is there's got to be a way where, that can happen when somebody becomes unmanageable at Halava, that there's a way to, get them over to the Department of Health or whatever it is, and, it's probably easier said than done, but there's a policy that says that's what should happen, But I agree, with the new jail, I mean, why not? Why not have the Department of Health be a part of that? And in the community and in probation as well.
Thank you.
Thank you.
I want to bring up one other thing that was in the report from Dr. Stewart. And he quoted on page 18, our policy that allows for people who have outstanding disciplinary charges to be resolved once they're released from suicide or safety watch. And that was something that seemed to be hanging over Joey's head. He was being told to be put into solitary confinement upon release from the watch. It's unfathomable to me that they would say that to a mentally ill person. When you get out of this, you're going to the hole.
Yeah, I just want to point out that, at the same time, we're revising the suicide prevention policies, 2013, 2014 timeframe. We're also revamping our policies on solitary. Restrictive housing is the term that's commonly used now. And one thing I recall about our policy was that nobody goes into any kind of restrictive housing unless cleared by mental health. So apparently that's a second policy that wasn't followed.
And obviously our psychiatrist at Halava did not know about that policy.
But to speak frankly about this, the mental health staff have little to no authority in the correctional system. Yeah. The guards run everything. The custodial people run everything. There is supposed to be a way that, because Joey was written up because he attempted suicide, and he was, which is totally, it's so outlandish that would happen. And then after his suicide, supposedly suicidality somehow resolved, then he was going to be punished for the fact that he attempted suicide. I think they got him for dismantling a fingernail clipper or something like that. And that was what he was written up for. And just one thing, and again, I appreciate the commission's taking time to listen to this particular case, but I have one very serious concern that I would sincerely ask you if the commission could look into immediately. And that is something that Mr. Livingston mentioned earlier, that one of the things that we noted is that the suicide and safety watch cells at Halava are not suicide proof. I don't trust the department to have resolved that issue. I would personally like someone to go into the suicide and safety watch areas to inspect each cell to see if in fact they are suicide proof. That's something that I would hope could be done immediately. Because you know, just because the department says they fixed it, I don't trust them at all.
You want us to provide oversight, in
Well,
other words.
Yeah.
It's in our name, yeah.
I mean, just call them up and say that I'll be by there this afternoon and I'm gonna just walk through the area. I'll do that. You know, that's another thing. I just wanted to make myself available. I don't mean to impose myself in anything on the commission's work, but you know, I do have a lot of experience in correctional psychiatry, and I've been federally appointed. I'm a federal appointed monitor right now in the state of Illinois, overlooking the whole system. And I've been a monitor in California on 2 separate federal cases. So whatever I could do to help out, I want to volunteer my services.
Dr. Stewart, is the Prison Law Center, do you know them?
Yes, I do very well.
They're up to speed. I think I know the answer, another softball question, but you trust them, you work with them, they're collegial, they're straight up.
The prison law office in Berkeley, California. Is that
Yes.
who you're referring to, Judge? Yes.
That's who I am, yes.
They were one of the lead counsels in the big California overcrowding case that went up to the Supreme Court. And yes, they do very good work. And
Who do you work with there? What human being do you work with collegially?
Oh, you know, as soon as you asked me the name, I had a complete blank. See, because I'm much older than all of you, so that's why I can have that.
No, you're not.
Yeah.
You're not older than me.
Oh, man. You know, the head of it is Donald Spector. That's the guy's name. He, at least when I worked with that office, he was the executive director. And he's a very good prison litigation expert.
Thanks.
I would echo Tommy and Dr. Stewart's comments about our interest and determination to continue to work with the commission. You know, looking at the commission's mandate, you've been given the Herculean task of cleaning out the stables without a shovel. You know, although it sounds like you've got a coordinator coming on, but clearly the work which starts at pre-incarceration, as Mr. Sakai was pointing out, and going through the period of incarceration and then re-entry. I mean, your mandate covers the whole spectrum, and I would love to be of assistance, and I think I speak for all the members of the trial team, for Mike O'Malley. Bob Merce, of course, is a leader in this area, and Dr. Stewart has given so freely of his time, and is really appreciated. And we're determined to keep working, and hopefully we can contribute to the commission's work going forward.
Just want to make a few comments as we close up on the discussion, and I really appreciate Mr. Malley, you having the courage to come forward and share your story and what's going on. But I'm going to share from my experience, and not in defense of anything, but just to go through my thoughts as I speak. Back in 2002, I was a correctional captain at OCCC. And we had a lot of struggles with the Department of Health because we were being told by the courts to send bodies to determine fitness to move in a case, and they weren't taking the bodies. We literally had my officers calling me from Kaneohe and say they won't take the body, you know, until we had to have our individual AGs work it out and say, yes, you have to take it because the law requires you to take them. Yeah. So that's a historical occurrence. Yeah. I share that with you because as a correctional captain at Halava, at the women's facility, at OCCC, I have made the statements to my superiors that the custodial staff are not equipped or trained or within their job description to deal with the most unmanageable of these mental health cases.
Yeah.
Yeah. And I put it in writing so that you guys know if anything happens that you were informed. Yeah. But if need be, we should be contacting the state hospital to transfer these individuals. It's only we want to do these transfers when we are not able to maintain the level of care that the individual should have. I'm sharing that with you so you know that there is custodial concern. But at the same time, we don't control or have any say if that movement can happen. And if the Department of Health says no, the body won't move. Yeah, that's a policy change. Yeah, at some point when public safety can dictate, or not dictate, and there's paperwork that's involved with our mental health people in public safety, custodial, that's submitted to the hospital, but they have the say whether they want them or not. Yeah, and so we're kind of, that puts us in a bind because if they say no, we continually have to try and manage the case. Yeah, which can become difficult. I apologize if I keep on saying we because I no longer work for public safety, but I'm sharing some of the frustrations I had in trying to move an individual who needed more care than public safety could have provided at the time.
Mr. Patterson, if I could say on that, you're absolutely right. When we have these mentally ill patients that require more care than can be provided, it puts your custody staff at risk for assaults, for being feces thrown at them, for who knows all kinds of terrible things. But also, now think about this. This is something that I would just ask the commission to consider. When a person has a heart attack at OCCC, there's no hesitation of putting them in an ambulance and driving them over to Queens to the emergency room, where they're seen medically. There's a couple people that are currently in the inpatient unit, medical inpatient units at Queens now because of medical issues, okay? What's the difference with psychiatric issues? Psychiatric problems are medical illnesses just of the brain. And so we have this sort of false distinction between medical and psychiatric. There's no difference. If we're able to take medical patients to Queens emergency room, and I'll get in trouble here with Queens. I'm not trying to say we need more patients, but we're full all the time. But what's the difference between medical and psychiatric and getting proper care? You're not going to let a guy with a heart attack or a guy having seizures stay in his cell and seize uncontrollably. So why, if a person is schizophrenic and banging their head and hearing voices and threatening self-harm, why should that person be allowed to stay in the jail? There's no difference.
What I'm trying to say is that we are, as a state system, we are not equipped or have not yet put in a system where that can occur. This is the change that we're looking at. We're already looking at, when we look at bail reform, we're looking at all these people that are in jail right now, and it's a lot of because of mental health illness.
Yeah.
Yeah. So it's systemic. Yeah. Public safety has some responsibility. DOH probably has more responsibility. So the answer is, how do we create that continuity of care, which does not exist for us to relieve these situations as they occur along the services?
Somebody used the word silos, why we work in silos, and I think it's a large part of it. I recall those days in 2002, Mark, and part of the problem we had with the DOH, with the state hospital, is they were under a consent decree, which capped their population. And if you look at their population, even today, it's about 90% forensic cases, unfit to proceed or acquitted, but committed to the Department of Health. And if you look at those who are in that category, those forensic cases, I haven't really gotten any numbers, but I would bet you would find a large number are there because of minor criminal violations. And you would wonder if there were community treatment services available to keep them out of the justice system in the first place, would that help the state hospital, not only the correctional system, but also the state hospital, to make more room for people from Halava, for example, who really need psychiatric treatment. So it's a big problem that's persisted for decades, actually. But we need to address. We can't just say, look, it's been there for a long time and we can't do anything. I think we have to start somewhere.
And so my point was is that you don't want to just fix one part of the system.
No, you can't.
We have to look at the entirety of it and then have those discussions. Because everybody's dumping on public safety, and it is what it is at this particular point in time. It's going to take some a lot of discussions and planning to figure out how do we attack this as a commission on a systemic level. We can hold public safety accountable for the management of what they have, but in order to really help them is to create the external community so that there are avenues of transition.
Chair Patterson, can I say a couple of comments?
Yes, Mr. O'Malley.
Yeah, number one, I agree with everything you said.
Yeah.
To the extent I conveyed any finger pointing at ACOs or public safety, that's not my intent and that's not my experience. I have a lot of personal friends that are ACOs. I know it's the system that needs to be fixed.
Yeah.
And so I hope I didn't offend you or anyone else who comes from public safety or that background. It's a heck of a tough job, especially when you don't have the system that you need. So that we're not interested in I'm not interested in scalps or finger pointing. I'm interested in let's fix things. So I apologize to you personally if I conveyed anything other than that.
You're fine, thank you.
And with Mr. Otake, with his comments about that we have an opportunity with the planning of the new jail to do a better job, at least at that point. And Mr. Otake, I don't know if you're aware that the commission is taking a position. We support a new jail. We just don't support the size that's been proposed. But we want to get very involved. And I agree with you. We need to make how we treat those who are mentally ill and address those who are mentally ill. The new jail is going to be very important in the planning process.
Thank you. And I think it's again an opportunity to have this conversation at a higher level within the executive branch. I mean, you're right. It's not just let's talk to the director of DPS. Let's, because, I appreciate everything that, Mr. Patterson just said. And that's, like I said, I really feel in a way for the ACOs who are put in this position, I mean, not having the training, not having the expertise. And it shouldn't be where, it's a DPS shouldn't be a dumping ground for the, our most serious severe mentally ill. And that's going to take a conversation at a higher level in the executive branch to have force that kind of coordination. And I think the new jail provides the opportunity to create a model or have that conversation, where you have the Department of Health and the Department of Public Safety working together within that facility to deal with these issues. And so, like I said, we appreciate all your time this morning, and however we can help share this story and be involved in advocating, and we'd be happy to stay involved. And we're going to be working on it as well, as just public citizens committed to making sure the new jail is designed the right way, at least trying to. So however we can help, we again appreciate everything you guys are doing. Really good.
Chair Patterson, I had a question because Bob Mercer can fly at either 30,000 feet, 10 feet, or 6 feet, but he's been to Norway. He's seen it. He wrote the principal paper in HCR 85. And if there's any indifference by anyone, and including myself, I want to know about it. If it's deliberate indifference, that's why we're going to end up with a federal class action. That cannot happen. It's a constitutional violation, and it's my fiduciary duty to get the best help. And I don't want to step on any toes, but so be it. Bob, you have anything?
No, I just think it's been a wonderful discussion. so glad that you scheduled this. I think there's just been such great interaction here. I think I don't have anything to add to it. It's really been remarkable. Thank you. Thank all of you, and particularly Mike O'Malley and the staff of his lawyers who had the courage to take this case and to break through this barrier and start the movement for change. I really appreciate it.
Yeah, and I also wanted to address Chair Patterson's concerns. I'm certainly not a custodial staff basher. I recognize how difficult their jobs are, and they need the proper support, which is proper mental health care to keep them safe, to keep the prisoners safe. So I certainly am not just looking at them as a scapegoat. And I'm aware that this is a multiple system issue. It isn't just safety, it's Department of Health. And I've been around in this litigation long enough to just have a bad feeling that, some people are going to look at this from the outside and it's not defensible the way the things are right now. And I'm not encouraging anyone to do this, but I could just sort of read the tea leaves, and it looks like this is going to end up in federal court and going to get a consent decree or some big ruling. And so I would love to see us address this prior to that point.
There is no doubt a lot that this discussion has put into my head. Lately, I've been doing a lot of systems thinking. Yeah. Managing a homeless shelter for 18 to 24-year-olds on property, we are seeing within the last 4 years, 75% of them have some type of diagnosis. Yeah. So now in my current position, I'm seeing them early. Yeah. And then already they're homeless. So the system is on my mind already, Dr. Stewart, because as we're looking at the situation at Halaba, that's like a journey, One of the journeys that we're looking at the homeless in our communities and the amount of mental health that are there. So that's when I think about a systemic problem and how do the state create the means for which to help manage through multiple departments.
Mark, you might recall that when the pandemic first started 2 years ago, we wrote a letter to the governor advocating the reduction of the population of our correctional facilities. But at the same time, we also urged the governor to convene a group not only of public safety, health, I believe labor, housing, and social services to look at services needed to support people who are going to be released into the community. And I think this is the scope of the kinds of attention that's going to be needed to solve this problem. Otherwise, we're going to build a 1,400 bed new HCSOC and find out 5 years from now, it's not enough.
I think this is the perfect timing for all of this to come forward in a public setting, in a public hearing. We are in an election year, so however that can be strategized, and we all know that we're going to have new leaders come November in all the departments as well as executive. So we need to get our strategies communicated and down when the leadership changes to offer solutions to the situations in public safety regarding mental health. So.
And Mark, are you suggesting that we as a commission should convene some type of community meeting?
Yes, I'm not ready to how that will look like and how do we communicate that. I do know I'm probably going to have, through Bob, have some more conversations with the gentleman to help clarify and put thoughts together. But yes, that's going to be on the agenda soon, Martha.
Okay.
Well, I have, let me just, it's not quite a dissent, but I think we need to think more about whether we should convene such a meeting, because our recommendation as regards to new HCSOC is that the Department of Public Safety should convene such a group and lead the discussions on this. And Max, if you're still there, I don't know what, if your position is still the same, that you prefer not to do such a thing. But I think such a discussion amongst the broad community is really needed.
I
And
think we can look at the issues as pertaining to public safety as brought up today, and specifically Halawa Correctional Facility and the treatment of mental health in the system. But there's also discussions outside of our mandate in terms of the entire system.
right, I understand that, but you know, I don't want to end up with another HCR 85 report.
Right.
And it was a great report, but it sits there, and the only products really have been our commission and which, well, you know how crippled we've been, and passage of one bill, reform bill. That there really needs to be a system overhaul.
Yeah.
Well, colleagues, I need to excuse myself. Thank you very much.
Thank you, Doctor.
Thank you, Doctor.
I want to just reiterate my appreciation for the commission to be able to take time to listen to us. And I seriously want to let you know that I'm available at any time to help move this system forward.
Thank you.
Mahalo, Dr. Stewart.
Okay, my pleasure. I look forward to seeing you all again soon.
Thank you, Doctor.
Bye now.
So me personally, I just trying to figure out the next steps is still in my head, Martha, really.
Okay.
Mark, can I respond to what Ted had asked?
Yes, Max, please, thank you.
Yeah, last year you folks wanted to set up the community advisory group for the planning of the HCSOC, and I was in favor of that and said that we would participate. I asked that the commission, you know, define who the members were. That never materialized. Department on its own has reached out to it's not finalized yet, so I don't want to say who, but a higher learning facility to assist us in a higher level planning group. And you know, we have a lot of support from various community members, and they want to participate. So hopefully we can get something formalized in the next month or so, and then I can report back to you as to what we plan to do as far as the department itself taking on its own community advisory group.
Can we participate in that, Max?
Sure, I'll be invited.
I think that would be a good idea instead of you just reporting back what they're saying, if we became a part of that.
Yeah, it's you know, definitely not all of you could participate because of, I believe, sunshine rules will prevent you from doing so. But hopefully by then your coordinator will be on board and could invite that person.
Okay, thank you.
Mark, if I could make another comment. And,
yes,
and to Mr. O'Malley. Mr. O'Malley, deepest condolences for the loss of your son. You know, this is kind of weird, but I thank you for suing us because it did bring attention to what we needed to do and what we can do better. And while I'm here, you know, we do plan to make things better and hopefully to prevent these types of situations to occur in the future.
I appreciate those comments, and I want you guys to know that I've had very positive experience with certain members at HCSOC in my visits and others. So it's not about bad individuals; it's about a broken system, I think. So we can fix that.
So we're trying to you know, make repairs to the system as best as we can. And you know, Mr. Otaki, thank you for your comments. Yes, the legislature did not fund our requests for the new jail, for the design and, you know, further implementation of that project, but the department will do its best to try to keep it alive. Legislature also didn't fund our construction request for the expansion of the mental health treatment facility at Halawa Correctional Facility, which would have helped the inmate population there. So we will go back again next year. And hopefully we will have support from Mr. O'Malley and the commission to support these projects that are badly needed with the Department of Public Safety. Thank you.
And harped on this many times, but it's the Hawaii State Legislature needs to be brought on board and really help us resolve these problems. Because over the many years that I was with the department, and I know Max has experienced this, as a result of suits and stuff, we put things forward, and very often the legislature doesn't fund it. And so we really need assistance with the legislature also in testifying and urging people to pass the funds we need to get these jobs done.
Once again, thank you folks for coming and sharing and bringing forth this information and that is needed. There will be a commitment by the commission to begin steps in creating those changes that are needed within public safety as well as in the Hawaii system as well. Not easy to identify that right now because it is a huge issue, and it's an issue that, as we can see, no one has resolved yet in terms of our homeless population and mental health. So you have set us on a task and we accept it, and because it is needed. And again, I thank you folks for being here with your time and sharing the information.
Mark, I had one more thing from the chat. If I could ask Max, what is the department's position on the bail reform? Because it's very important to us, and there's a lot of discussion both ways, some of which is grossly misunderstood by the public.
Judge, our testimony has been consistent throughout the legislative session is that we did not testify for it or against it. We provided, a page and a half of comments specific to issues that pertain to the department. One of the big sticking issues for me was the $99 or less, and that I shall release the inmates from custody, which would override the judge's decision. So that was taken out, I think at conference. The other issue, I think, was the videotaping or video conferencing that is still in the bill. Our practice has been face-to-face, but now, and we don't have the capability of doing video conferencing interviews at the HPD cell block because we go there face-to-face. But now if the defendant says he wants a video conference, we somehow got to provide them the video conference, and I'm not sure how we're going to do it. Provide them a tablet while we stand outside the door and talk to them. I'm not sure, but these are issues that we brought up logistically that did not make sense for us. But as far as the bill itself and the purpose of the bill, we did not testify for or against it.
Thank you.
Your comments and recommendations to the governor, what are you saying?
It's basically the same thing that's consistent with our testimony in the past.
So you're expressing concerns. You're not saying don't sign. You're not saying do sign, just expressing concerns.
We're also expressing concerns, and if diversion is going to take place, there needs to be resources of what was discussed today. There's going to be resources in the community that's going to be needed to divert people, because diversion without resources is very risky.
Thank you.
Thank you, Max.
That question, Mike, any more comments on the final item number 7 on agenda items by the public before we end our meeting?
Yes, I have something to say.
Go ahead, Kat.
When we talk about the new jail, one of the things I want people to realize is that in the environmental review documents, they called the building correctional reform. That is not, a building is not correctional reform. We need to figure out how to train people. So I'm curious, what is happening with the trainer who was arrested? Is she still around, or if she's not, who is training? Max, this is for you.
Well, the question should come to the commissioners, Kat.
Okay. Okay, to the commission.
So the question should be for Max is, has there been succession at the leadership of the training since what was reported in the media?
The news.
So to answer your question, the training officer that was arrested by the Attorney General's office has been placed on leave. Pending investigation, another internal investigation by our office. Right now, we have a lieutenant, a training lieutenant that has taken over as a temporary assignment as the trainer of the, and he has many years of experience with our training division. We are unable, the position is still currently filled by the person that's on leave, so we're unable to put the person, we are unable to fill the position permanently at this time. As far as the training goes, training, all of our training curriculum is approved by the training, committee, which makes up of departmental heads, and the training officer herself is not responsible for the actual delivery of the curriculum. We have numerous trainers that work for the department that their job is specific to training our recruit classes, and they're the ones that actually deliver the curriculum that's been approved by the department.
Max, a couple questions, and really, I'm allowing this line of question only because of some of the things I was mentioned in the prior agenda item. And just to acquaint myself with the system, the lieutenant that's being temporarily assigned, is that a sheriff or correctional officer?
He technically is a training staff. The trainers were merged into Department of, the TSD, Training and Staff Development Division. They were merged in there, and most of them are classified as trainers, although they have law enforcement background. But yes, he has a law enforcement background.
Okay, and then secondly, the facilities all have assigned specific staff for training. Are they conducting annual training for the individual facilities?
The training sergeants at each correctional facilities have been assigned to keep up. Because of the pandemic, we have been not as punctual in keeping up, but they are beginning to try to catch up as far as training that needs to be done.
Understood. Okay. Thank you. Any more questions from the or comments from the community at this time?
I would like to say, this is Carolyn Eaton, that when you're talking about diversion, I believe that some of the people who would be involved in being released, if the cash bail reform went forward, would be with their families. I don't know what the proportion is, but my goodness, diversion isn't 100% required. It's the family, they go to their family where they've been living.
Thank you, Carolyn. Housing, often in diversion, you create programs at the front end that may be a requirement of the judiciary for them to attend. Those are some of the resources. Not all of them will be required that. Yeah. Okay, everybody. I appreciate the time and you folks took off to come and be a part of this meeting. We're looking at our next meeting. Martha, you got a calendar in front of you?
No, I don't, but I can pull it up.
I'll pull it up.
I think June 16th is a next third Thursday.
Will be June 16th at 9 o'clock. Commissioners, any further questions?
No.
No, good discussion. Thank you.
Okay, that was a great discussion. A lot of thought still needs to go into what we just heard, especially for me. And just want to wish everybody a good day. And we see you next month. So aloha.
Thank you, Mark.
Yep.
Thank you.
Aloha.
Thank you, everybody. Aloha. Nice shirt, Mark.
Thank you.